Where is my choice? Facing and going to prison, there's really no way to dress this up. But if the rumors and whispers that the FBI has been poking around are true, I'd take it seriously. I say this because I didn't, as I thought this was all a big mistake. And in the end, I was wrong. Several of my surgery patients had come in to let me know that the FBI was asking questions, and it just didn't make sense. They were having patients. They met the feds and said that the surgeries were done, everything was fine. They showed them, whatever they needed to see. But in the end, it doesn't help me to look backwards. Hello and welcome. My name is Marc Blatstein, and I'm the physician who founded Physician Pre-Sentence Report Service. After 30 years in practice, one morning I was interrupted by an early 6 a.m. knock at my front door. Let's see here. And again at 8 a.m. at my medical practice, interrupting patients and staff, all for a problem that I created. As I was guilty, I pled to a felony and was convicted of a federal white-collar crime and sentenced to time in the Federal Bureau of Prisons. Now, I was considered a justice-impacted person. After my release and several years of hard work with support of colleagues from locally and around the country, my medical license was restored in full in 2010. Around that time, I chose to use my skills in healthcare and medicine, along with my understanding of the BOP, to assist those of you who, like me, found themselves facing the criminal justice system. You see, at the time, I realized that I was just completely unprepared in so many ways, it's not even funny. And I made it a mission to provide those of you with the resources that you will need, as you see if you go to my website, Physician Pre-Sentence Report Service, so that you'll be prepared, because in prison as in life, preparation will mean survival. And while your stay will be in prison is temporary, and it will be a bit unsettling for some, it was at times for me. The goal is to be productive and follow your reentry plan and get home as soon as possible. So as they say, let's get to it. My attitude is that there are values. The core values are three: preparation, self-advocacy, and reentry planning. These core values will guide you through this rough patch, and the rough patch for some will be longer than for others. But to be honest, once you go in and pass through the bars, it's not easy. And judges want to hear from all of us. Before we even get sentenced, they really want to have a conversation with us, because before that day at sentencing, they know nothing about us other than possibly what they read in the paper. All the information they will get and learn about us, they are going to learn from the probation officer. That means that a date that we have our pre-sentence interview, which we're going to go through and go into, is a significant date that we have to prepare for. But I go too quickly. So we're going to continue. Preparation. These slides are jumpy. Once we're guilty, and this again, I jumped too fast, but it's going to start initially with the feds. Once you're on the radar, they're very confident, and our choices will be either plea or trial. They have a 98% conviction rate. And with that 98%, if you choose to go to trial and lose, they're going to want to get their pound of flesh. So pleading is mostly what people do. And with that preparation, with that plea, you get a lesser sentence, but it still can be significant. Go to trial and it can be much worse. But if you plea, either way, you start interviewing attorneys. And you need to ask questions. I mean, you may be like a deer in headlights, which I was, but you need to ask questions. And you want to get referrals. You want it rather than referrals. You want to get references. And so don't be embarrassed. Ask the attorney if you could have a couple of references to call for people that had a case similar to yours. I'm sure that they can find a couple pleased clients that would be willing to spend a couple minutes to speak with you. After that, you want to see if you can ask for a couple memorandums and memoranda you could look over. Memorandums, these are what the attorney will submit to the court a week before sentencing. And for the memorandums, you want to be able to review them. And if the attorney says, well, they're private, confidential, and tell the attorney you can appreciate that. Thank you. But all they have to do is block out all the personal information. You don't need to see the whole thing. But you want to see enough of it to see if they look the same or if they're different. And if they're boilerplate, which means they all look the same, this is not where you want to be, for sure. So what are your options at this point in time? Well, you've got work to do, for sure. You're going to be asking questions and you're going to be getting references. You need to look at the memorandums, but you're going to be preparing for the pre-sentence interview. That's going to take a lot of work on your part. You've been to the doctor, you have to get lots of medical records, especially if you've been lots of doctors. You have to get prescriptions. You have to get copies of all your prescriptions. You've got to get records. You have to, if you've been to X-rays and CT scans and MRIs, have to get copies of all of those. Plus, you actually get all of them on CDs. And if you've never done this before, you should get 2 copies of each, one for your records and one for the court. In addition, if you've had surgeries, get copies of all the op reports and a copy for your own records. If you've had prescriptions, if you have medical devices, you need to get prescriptions for medications and for the devices. If you're taking medications and the Federal Bureau of Prisons have their prescription formulary online, you need to review them with your doctor and your attorney. If they're not available, if the drugs you're taking are not available by reviewing the formulary online, then you need to review the drugs that are available between your attorney and the physician. And if there's a problem, you may have to ask the attorney if you can do a video deposition or some sort of written deposition. More important, you need to ask the attorney if they're willing to come in to the sentencing hearing. Because if it's a life-threatening issue, they need to be there because the judge is going to want to talk to them. The idea being is that maybe you have to stay home. If you have not been to a doctor, or maybe you need to get a psychology or psychiatric evaluation, now's the time to get that done. You don't want to wait any longer. You need to be upfront and honest with your attorney. This is a joint project. If you're hiring the attorney, paying the attorney has to be willing to input from you. you need to be honest with yourself. It's taken me 12, 13, 14, 15 years to be able to realize that there were things that I didn't tell my lawyer because I actually believed them, but they were excuses. You don't want your attorney to go into the courtroom and have the prosecutor tell him things that he didn't know. Doesn't need to be surprised. Otherwise, he's not going to be able to defend you in the best way he can or she can. You are your best advocate. The only way to be that is to be prepared. Are you ready? Do you have confidence for your defense? Are your team partners, are they ready to prepare you? Invest in sentence mitigation, allocution and personal narrative, and reentry planning. These are like key parts for your pre-sentence interview that need to be done long before you ever get into the sentencing hearing. Allocution is a conversation between you and the judge. Personal narrative is where the information comes from for the allocution. Personal narrative is your story that you need to start writing and write it after the guilty plea. It takes time to write that personal narrative. It may have to be rewritten a dozen times. It starts from when you're a child and what your life has been like. And it's a conversation between you and someone who's done this before. And it takes a long time. Reentry planning is almost a specialty unto itself. And judges want to know about the reentry planning. What are you going to do if we let you, if we give you a lesser sentence and then let you get into halfway house and then start over? What's your plan? And so to have an attorney not ready to start you on something like that, it's not unusual, but to the judge, to the court, and to the probation officer, they want to know. And so being able to provide these mitigation services, it's part of mitigation is, do you start a website with a blog right away? As soon as you're done your personal narrative and make your statement to the world that this is what you did wrong and this is what you're going to try and do to correct it. These are the steps you're going to take. This has to be done before your pre-sentence interview. It's a big deal. If not, and if you don't feel 100% comfortable, there are no redos. This is your future. You kind of have to make a decision now what to do. Do you increase your legal team? Self-advocacy. These slides have a mind unto their own. Interviewing the attorney, you've asked for references, good. Personal narrative can take a month, every day of a month. Sometimes it can take 6 months. It can take a long time, and you may not have that long. Remorse and insight as to why you did what you did, what you're doing to make sure it doesn't happen again. The defendant has to have insight into the harm he's done. Does he have the capacity of introspection? And has he she come to grips with the impact of the offense that the offense has had on others? Is the defendant sincere, and has he demonstrated insight into the crime? This starts as your story, going back as far as you can remember. The pre-sentence interview, we've touched on this, is all the records you need for trial for the judge. I mean, again, if you need a psych evaluation, a medical evaluation, you and your attorney has to work as a team to help getting your message on the record. Your attorney, as soon as you've left the guilty plea, they're reaching out to the probation officer to intuitively find out, have they spoken to the prosecutor already, which means that they've been tainted as to whether you're guilty or innocent. If not, that gives your attorney an opening gives them an opening to get their message on the record first, to find out what documents they need. if they, what documents they need what documents they need once they do the probation interview. And then when is their official pre-sentence report deadline? When do they have that completed? There's a lot that goes into their preparation for the pre-sentence report long before you have all their material, all their information hard copy to give to them, as well as your personal narrative documentation. Not even talking about the website blog, should you agree to try and put something like that together, which could be helpful and definitely would be agreeable to the court or to the judge. So you're working together with your attorney as a joint venture, trial or plea. You understand the difference between the both. Plea, trial, they're definitely going to want to get a pound of flesh from you if you lose. Allocution, that's a big conversation between you and the court. The version of your personal narrative. You should be ready and comfortable to have that conversation. Your memorandum. At the sentencing hearing, you know what the attorney's going to say. You've already practiced both of those with your attorney. Your personal narrative, taken a long time to write. You know your narrative. You're ready to have the conversation with the probation officer. Your pre-sentence report is mostly complete. You're relying on the skills that have made you successful. Back up a slide. It jumped too quick. Your mitigation strategies before and during incarceration are beginning to take shape through the website and a blog that you've put on that website. And you're beginning to prepare in depth for your pre-sentence interview. And you're working together hand in hand with your attorney. To be honest with your attorney about everything. Again, you're not surprising your attorney. Everything needs to be included into your pre-sentence interview, PSI. Character reference letters need to be reference letters about your character, where they also know about the legal the fraud, the criminal charges against you, all of your letters about or documentation regarding your highest level of education that you've achieved, military, if you have any military service, all of your certificates regarding that, or the letters regarding your military background. As I said, your attorney has connected with your probation officer prior to your interview to get a pulse on what they know and hopefully present their case and their defense strategy. They need to know that the final date regarding the pre-sentence, when they have to have their pre-sentence report or PSR done. And then RDAP. If your attorney tells you that don't worry about RDAP, don't do it, don't, just leave the drug program alone. Don't listen to them. RDAP can get you a year off your sentence. Whether or not you need it is a completely different story. But take it, for me personally, I thought it would be a problem, so I didn't include it. Well, it could have hurt me. And it turned out maybe it did. I don't even know. Because as I said, I was a deer in headlights the entire time. But for 18 months or so before this even happened, I was drinking a bottle of wine a night. It's 3 water glasses. That's all. And so a substance abuse problem is a alcohol or over-the-counter medication or prescription medication or illegal drugs within a year of the arrest. And so if it is applicable, then it should be included, because if it is applicable and not included, trying to get it applicable after the fact is a very big lift. And it may come out to burn you. Whereas if it's in your record and you don't need it, it doesn't hurt you at all. Further, compassionate release is not a law. It was put in place during the height of COVID. But if you have serious medical issues, immunosuppressive diseases, if you have organ transplants, medications that are not available, it likely is very important to get physician testimony where you have his CV and testimony in written format, as well as being asked to show up at the sentencing hearing as a witness, so that the judge and the court can ask questions. Because with COVID and the medical facilities as they exist today, it may, if in fact it is detrimental to your physical health to be there, this may work, unfortunately, in your favor, but the only way to know is to have your physician in the courtroom. First Step Back programs, your attorney is going to be able to know your public safety factors, your criminal history, and it's very important for you and your attorney to go through all of that. Excuse me. And it's important because your probation officer is going to go through it. Your probation officer is going to go through your public safety factors and your criminal history and your offense level, which is your charges. And they will know it, so your attorney should be going through it at the same time, because it will determine your placement. And with that in mind, your First Step Act programs will also determine where you're placed. And so you should know your public safety factors, just in case they are not scored, and your criminal history scores, in case the probation officer doesn't score you appropriately. And these can be adjudicated before you have your during the pre-sentence interview or ahead of time. So that this is very important to be done before you get the probation officer makes their way to the interview. In addition, using the First Step Back programs, let's say you're autistic or borderline personality disorder. The BOP only has 2 prison facilities that support that nationwide in reality. And they're security level specific. They may have a couple others that they say support it, which can be either with a psychology or educational staff. But they only have 2 according to their actual program list. If you have dementia, there is 1 location nationwide. Anger management, there are specific locations. And so consequently, you need to know this. Your personality is going to take time. You need to know it cold to be able to discuss it in first person with your probation officer casually and sincerely. And after going through it, writing it and rewriting it a dozen times, you will come through honest and sincere. And then it can be copy pasted into the official pre-sentence report. This is your story. It will be in written format. And if you choose to have it put into video format, it can be. Video format can cost $25,000 or more. That is an option, or it can be done cheaply with a smartphone. 1 picture is worth 1,000 words, as they say. Time must be allowed for the development of your personal narrative, and it needs to be done with assistance. It can't be just done between you and a relative. It doesn't work that way. You need another party involved in its development. It's only then that the pre-sentence report is complete and includes all of the above. Judges want to know this. So using RDAP as an example, and the judge, let's say they agree to your allocution and departs downward. So where the RDAP is an example, let's say the judge agrees to get to order RDAP. Then if you now are able to do a placement request, only request one prison. Don't ask, can I have a camp? Can I have a this? Specifically request one specific prison based on a reason. And the reason is an RDAP program, period. You don't want it to make it complicated. It's got to be based on a program. Next, if in fact you want to ask the court, if the BOP cannot notify, they cannot place the person in if they cannot place the person in that particular BOP facility, can they notify the court in writing as to why they cannot make that placement? And see if that also could be placed in writing into the court so that you can get that notice back from the BOP to the court. So the core values are, going backward, preparation, self-advocacy, and then reentry planning. As I said at the very beginning, judges want to know. Probation wants to know, what are you going to do? And so there are many things that are being done for reentry planning. The strategies before sentencing, website, blog, accepting responsibility through a heartfelt personal narrative that was then explained during the allocution through the sentencing hearing directly to the judge. And what is this important? For sure. But additionally, and we'll take a little time here, while you're incarcerated, you're going to go into, when you get to prison, you're going to have your meeting with the unit team, case manager. And when you're going to meet them, you want to tell them you're going to request that you take the scoring test. You want to take that test. Spark 13. You understand? It's a risk. It's a risk it's a criminogenic risk score, or criminogenic risk assessment score. And you heard that it's a good program and that you would like to take advantage of it. And then once you take the test, they're going to recommend certain programs for you to take. Be thrilled when they offer a program that is on knitting or crocheting or walking around the track or managing a checkbook or whatever it may be. You're thrilled. And you take the class, and in the meantime, order from Amazon some sort of notebook that is softback, that doesn't have any metal spirals in it, just a straight, generic softback with pages with lines in it that they have to have writing in it. So it would have to have some sort of religious writing in it, some inspirational writing in it, some sports writing in it. It can't be a daytimer, but something where you can make notations in it that, where you note, where you can make notes every day of every week that you note the day when you go into the class, when you go ahead and you say that the teacher, and this is the teacher's name, and this is the class, and it was a great class, and this is what we talked about, and I learned a lot, and you do it every day for every program, because these programs provide you with credits towards being released early. And at the same time, on another YouTube, we'll talk about books that you're having sent in to you. And these are books that are biographies of history, philosophy, business. And these are books, and you're choosing them by author, by title, or not by title, but by author. And you're writing a short little book report about what you've learned and how you can use them when you release into the job you're going to, into your new venture. And each one of these is also going into this journal every day. And if you can imagine that as you build this journal up every day, this is part of your personal narrative now, being built every day from two sources. You first step back, programming in these books, and it's going to also include at the very beginning, your driver's license, personal security, social security card, your address, it'll include a space for your driver's insurance, etc., who may hire you, that kind of information, personal contact, address, your legal address, your personal identified information, health insurance, etc. And then when you go into speak with your unit team and your unit case manager, that it'll begin to get full. And this will show unit team and case manager incremental improvements, which is a barometer they use that shows that you're improving and that you're decreasing your criminogenic need. You're getting better, basically. And they can now show it to their superiors, who shows it to their superiors, then to the warden. And the warden can then say that this particular prison is doing better than other prisons. And everybody heaps praise on their supervisors, and their supervisors heap praise on your case managers. And guess what? Your case managers may take you one step further to earlier release, which is where you want to go. And everybody, all the case managers and correction staff, they all listen to the same radio station. I don't remember the number. It's an AM station, and it's WIIFM. Remember, WIIFM. And that radio station is What's in It for Me. They get praise and recognition as you work your way home. And so, it's not as much quotes from federal judges as it is from the federal judge, from the federal lawyer. Views from the bench. Owners own the mistakes and demonstrate remorse. Just Judge Richard Kopf from Nebraska was in there. Judge Levy from Maine. Judge Sarris from Massachusetts. Judge Bashant. Judge Marc. Judge England. One of the biggest mistakes defense lawyers can make is not having their client answer the question. Judge Lawrence O'Neill. Judge Berdar says he comes out to the bench with the sentence already in mind, but allocution, however, changes this when I see the defendant has insight into the harm he's done. National Association of Criminal Defense Lawyers, Champion Magazine. Heartstrings are heartburn, a federal judge's musings on defendants' right and rights of allocution. Judge Marc Bennett, a good allocution can be beneficial. These are judges, there were dozens. What do they want to hear? Allocution, personal narrative. We're interested in a defendant who has the capability of introspection, who has come to grips with the impact of his offense. No punishment would be enough. If I could change back what I did, I would. I'm persuaded that the defendant is sincere and demonstrates insight. I am persuaded. Allocution is very important. I'd like to have a conversation with the defendant. I want him to apologize to the victim and his family and her family, particularly if they're in the courtroom. Allocution, however, changes this when I see the defendant has insight into the harm he's done. I'm looking for remorse and insight as to what he did and what he is going to do to make sure this doesn't happen again. It's very important that lawyers prepare a client for allocution, even if they have gone to trial, and do the job that they were retained to do. Start paying restitution, even $25 a month, and don't show up to court in a $900 luxury car. These are just some of the things that federal judges want to hear. This is our part of the personal story that judges want to hear. It could take weeks to months to write and rewrite, edit and re-edit a personal narrative, but in the end, you'll have stripped away all the excess elements of your life. And then you'll be left with facing what you did, why you did what you did, and how wrong it was, and in the end, whom you have harmed and why you won't revisit that event again. And there you will be, remorse for what you feeling remorse for what you feel, naked in front of the court. So you have a choice. Successful life after release. I hope you found this helpful. There'll be other YouTubes to follow. Consultations are on me. There's no charge. All the information is available on my website, PPRSUS.com. Physician present report service. There are things that can be done at any point in your process. And no attorney, no lawyer, no consultant can promise you any outcome. It's just not possible. All judges will do what they do at any point, at any time when they're on the bench. Nobody can promise any outcome. Again, I hope you found this helpful, and wish you good luck.